Just before I start, because what I want to look at essentially is the legal position, just let me say something about the situation in Scotland. The issue between unionism and independence, or separatism, has in fact a very long history in Scotland, going back to the late Middle Ages. But on the whole, in recent times, it's been characterized by what I would say are three things. First of all, an absence of repression. There was thought to be repression, there was indeed repression of the Highlands of Scotland after the revolution in 1745, the rebellion in 1745. But since then, as has already been remarked, Scotland has been part of Britain and an active part of the British Empire. Secondly, the issue of unionism and independence has been marked by a lack of passion, and it is inconceivable that you would find in Scotland the kind of demonstrations in favour of independence which we saw in the photographs from Barcelona. And that is partly due to an absence of provocation. There has been very little in the way of provocative acts on the part of the United Kingdom government. And I've always said that if the yes vote is to be won, it will not be won by the strength of the arguments, but as a result of some catastrophic folly on the part of the UK government. What it also differs in Scotland is the attitude of youth. The Scottish National Party insisted that a vote be given in the referendum to those who are 16 and 17 years old, and all the evidence of the polls suggests that they are going to vote no, and it is thought that the reason for that is that they're more concerned about their own economic future than about the issues of independence. Two events have occurred very recently, that's to say yesterday. One was the threat on the part of the owners of the refinery and petrochemical complex at Grangemouth, which is at the head of the Firth of Forth beyond Edinburgh, to shut down the complex, and that would represent a shutting down of 8% of the Scottish GDP. That apparently has been avoided this morning. The second thing announced this morning is that in the by-election for a town quite near that refinery, also near Edinburgh, the Labour Party took the seat from the Scottish National Party by a swing of 7%. So 600 majority of the Scottish National Party became a 3,000 majority of the Labour Party, which seriously affects the SNP's majority in the Holyrood Parliament. Right, now what I was going to do is simply to set out for you what I see as the international law aspects of Scottish independence, and then go into very briefly what might be the implications for Catalonia. First of all, as far as Scotland's concerned, it's not at all clear whether it would be secession, separation, or what, because the United Kingdom is indeed the United Kingdom of Great Britain and Northern Ireland. And according to the Treaty of Union, and it's been said we don't have a written constitution, but many Scottish lawyers would maintain we do, and it is the Treaty of Union. And the Treaty of Union says that the two kingdoms shall forever after be united into one kingdom by the name of Great Britain. Great Britain is by definition the combination of Scotland and England. So if you dissolve that union, what have you got left? Many people would argue in Scotland you do not have the United Kingdom of Great Britain and Northern Ireland. You've got a new state. But that's a matter perhaps of historical interest and not for us today. As regards international law treatment of secession or separation, where a smaller proportion of a state decides to secede, the remainder of the state will normally be treated as the continuing state and the seceding state as a new state. The continuing state succeeds to all the treaty rights and obligations. The seceding state, if it wants to continue membership of international organizations, has to apply for membership. And the question then is whether or how far that state will continue to be subject to any of the preceding treaty obligations. However, that's all subject to state practice, and just to give you some examples, the South Sudan was treated as a new state of the UN. After the dissolution of the United Arab Republic, both Egypt and Syria were treated as continuing states. After the dissolution of Serbia and Montenegro, neither of them was accepted by the United Nations as the continuing state, but both were accepted by the IMF and the World Bank. Kosovo is still not recognized as a state in by many other states. The Czech Republic and Slovakia, after what was called the Velvet Divorce, had to apply, both of them had to apply to join the Council of Europe, but both were treated as continuing states by the IMF, the World Bank, the Universal Postal Union, and the International Atomic Energy Organization. And the former Soviet republics were simply asked to confirm their membership of the World Intellectual Property Organization. So there is a great variety of state practice. As regards Scotland, what has been expressed as the official view is, Graham Avery has already referred to President Prodi, when a part of the territory of a member state ceases to be part of that state, the treaties will no longer apply to that state. Sorry, that's Prodi in 2004, Barroso in 2012 to the same effect. Van Rompuy, the president of the EU Council in 2012, has said Scotland will need to reapply for EU membership, and the UK government obtained an opinion from two professors of international law to the same effect. I take a different view, and that's what I'm going to explain. But I think it's important to see what the basis of this is. First of all, the separation of Scotland will occur as a result of a vote conducted in accordance with democratic principles, and in a manner accepted as constitutional according to UK constitutional law. I think those are two points of fundamental importance when discussing Scotland and Catalonia. Next point, a yes vote next year would not bring about immediate separation. Separation will occur only after a long period of negotiation as to the terms of separation and as to the moment of time when separation will actually occur. And as far as the EU is concerned, up to that moment, the United Kingdom as such, including Scotland, would continue to be the member state with all the treaty rights and obligations. Analyzing the legal position, we have to begin from the fact that the relations between the United Kingdom, including Scotland, and the EU and the other member states are governed by the two treaties following the Treaty of Lisbon and by the Charter of Fundamental Rights. And as a matter of international law, the rights and obligations under those treaties are to be determined in the first instance by reference to the terms of the treaties. And the Vienna Convention says treaties shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms and in the light of the object and purpose. Way back in 1963, the European Court of Justice said very much the same as the Vienna Convention, that it was necessary to consider the spirit, the general scheme, and the wording of the treaties, And having done so, the court concluded that the community constitutes a new legal order of international law for the benefit of which the states have limited their sovereign rights, albeit within limited fields, and the subjects of which comprise not only member states, but also their nationals. That is of fundamental treaty importance. These are not treaties only regulating the relationship between states. In the treaty as it now stands after the Treaty of Lisbon, we begin by saying that the Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights. And then the Union shall respect the equality of member states before the treaties, as well as their national identities, inherent in their fundamental structures, political and constitutional. So right at the beginning of the Treaty on European Union, you come back to the 2 points I've already made, democracy and constitutionalism. And then the treaty goes on to require the member states, pursuant to the principle of sincere cooperation, in full mutual respect, to assist each other in carrying out the tasks which flow from the treaties. I can't go into all of this. I pass over the provisions relating to citizenship, but the fact is that any national of a member state is also, by virtue of that fact, a citizen of the Union with certain rights. And also the treaties establish the internal market, which includes free movement of goods, persons, services, and capital. Finally, in the Treaty of Lisbon, unlike the previous treaties, there is provision for a member state to withdraw in accordance with its own constitutional requirements. But in that event, there must be negotiation, Article 50, Para 2, in order to establish not only the basis on which the state will withdraw, but the framework for its future relationship with the Union. And it's only after 2 years or any further period agreed that separation, withdrawal, would actually take effect. So my analysis is the following: that Article 50 expressly provides that withdrawal requires negotiation. Withdrawal would only take effect on the date agreed or 2 years after notification, but certainly not immediately, and that is evidence of the spirit and general scheme of the treaty, which you have to take into account in dealing with a situation the treaty does not deal with expressly. It requires a period of negotiation, and the reason is that withdrawal would require the unraveling of a highly complex skein of budgetary, legal, political, financial, commercial, and personal relationships, liabilities, and obligations. And these relationships, liabilities, and obligations are multilateral and in general reciprocal. That is important because it's not only that the Scots have acquired rights of citizenship and free movement, but so too have the nationals of other member states, vis-à-vis Scotland, its territory, its institutions, and its people. So what we have to imagine is that until the moment of separation, Scotland would remain an integral part of the EU. The Scottish people and all EU citizens living in Scotland would enjoy all the rights of citizenship and free movement, and the same would apply to all other EU citizens and companies in their relations with Scotland. Examples: investors in the corporate sector, hundreds of Erasmus and other students, thousands of migrant workers, and fishermen, and this is important, I think, fishermen from other member states operating in Scottish waters, which are the largest sea area of the European Union, whatever the standard of measurement. And that has certain echoes, not least for Spain. The legal question, as I put it, is that can it reasonably be supposed to have been the intention of the treaty makers, who provided expressly for the case of withdrawal, that in the case of separation of an existing member state, all these relationships, rights and duties, will continue till the moment of separation, and then, to use the words of Nehru at the time of Indian independence, at the midnight hour, everything stops. The rules on VAT stop. All EU fishermen are now excluded from Scottish waters. All Erasmus students become students from third countries. That is the consequence of this theory, and furthermore, it presupposes that neither the EU institutions nor the member states have any obligation to do anything to prevent that result. And my answer simply is that there are treaty obligations, and there's a treaty obligation of good faith, sincere cooperation and solidarity, and therefore the EU institutions and all the member states, including the United Kingdom as it exists, including Scotland, would be obliged to enter into negotiations before separation took effect to determine the future relationship within the EU of the separate parts of the former UK and the other member states. And the outcome of those negotiations, unless they failed utterly, which can't be excluded, would be an agreed amendment of the existing treaties and not a new accession treaty. And beyond that, what I say is there is no certainty other than uncertainty. And that leads me back to the situation of Catalonia, because a situation in which Catalonia declared its independence, but that independence was not accepted as constitutionally possible by the state which forms part of the EU, there is no provision of the treaty which makes it possible to deal with that, even in relation to the general spirit of the treaty, because on the one hand, the treaty expressly talks about the principle of democracy, but also the treaty talks about respect for the constitutional structures of the member states. And therefore, I'm not in a position to offer you any legal view as to what the situation would be. On the other hand, what does seem to me to be self-evident, but the point has already been made, there is manifestly an obligation of good faith to negotiate.